This really is a major day for the judiciary. It's a judgment that can have huge implications, and we're trying to understand those implications. Also joining us now is Orgyo Sengupta. He's the Research Director of Vidhi Policy Centre. He's also done a PhD at Oxford precisely on judicial appointments, and you also were briefing the government or giving your opinion to the government on this particular judgment. Your first reactions to what you've heard, is this about unconstitutionality, or is it the fears of the judiciary about political interference that has influenced the judgment?
I think there's a bit of both. I think before we can pronounce a definitive opinion on this matter, we'll have to look at the judgment. And of course, the judgment is expected to be quite a lengthy judgment. The court only read out the operative part of its order. So I think at first glance, it's surprising that the court has taken such a hard stance against the government. There was a view that the constitutional amendment, striking down of a constitutional amendment on the question of violation of the basic structure, is a really significant decision for the court, and the fact that the court has decided to strike down the constitutional amendment in toto and allow the old system, which had its share of problems, to revive, leads one to the inference that it's not just about the law, but it's certainly about the mistrust that exists in the current atmosphere.
But there's a feeling that the judiciary is asserting its independence.
That's right.
Is there a flip side to that? The arguments that you and others were making, or your belief, why were you among others believing that the Collegium system was not working?
I think the judiciary has asserted its independence, but at the cost of its accountability. And once we look at the reasoning of the court, we'll have to look at what the arguments on law are, because at the end of the day, it is a court of law which is bound by the Constitution of India.
Now, are you saying today judges are unaccountable? That the Chief Justice and the two top Supreme Court judges under the Collegium system who appoint fellow judges are unaccountable completely?
I'm making 2 points. Actually, I think one, the court as an institution itself, given the amount of power that it wields in the current constitutional framework, does not have the requisite amount of accountability that it needs, because it's making major governance decisions. And I think for a largely unaccountable institution to do that is gravely problematic. That's number one. But on the point of the Collegium itself, the fact is that the Collegium was envisaged by Justice Verma in the second judge's case as a collaborative process between the judiciary and the executive. We've seen over the last 20 years that in effect it is not a collaborative process. It is essentially the judicial voice which prevails every time. And we've had examples of that with Justice Dinakaran, who has gotten appointed despite many lawyers, including some of the petitioners, coming out strongly against him, was transferred to the Sikkim High Court despite the fact that he had a really spotty record. So the fact is that there are a lot of skeletons in the Collegium's closet, and for the court to say that the Collegium system, which is a non-transparent system, in my research for 2 years, I tried to get information about the Collegium, not a single file was forthcoming. So the court to completely shut the door on reform seems to be
No, they're not shutting the door on reform. They're saying now on the 3rd of November, you can bring in your plaints about how you want to reform the system.
But it's that gets us back to the fundamental question as to whether the Collegium system itself is legitimate or not. And that's an argument that was raised, whether that has any basis in the Constitution. Because just to give a brief history, the fact is that the Constitution uses the words, the President shall appoint in consultation with the Chief Justice of India. Over a course of judicial interpretation, which was concretized in 93 in the second judge's case and the third judge's case in 1999, we've had an interpretation by which consultation means concurrence. So that's a bit of a stretch to begin with, and that's the entire, if I may call it, the birthing defect of the Collegium. So to say that we are going to improve a system that is rotten at the core seems to me to be making a category
Those are
mistake.
very strong words, but you know, Vinay, that's an interesting point coming in, that while the judiciary calls for independence, it remains unaccountable. I think that's essentially what Orgyo's point is, that how are you bringing in a checks and balances into a system where every lawyer will tell you in the Supreme Court, so-and-so judge, you know, he has a spotty record. He's used the word spotty, some will say corrupt, or allegations are wildly made. You can't make them publicly because of contempt of court. Is there a point there that balance has not been struck, unfortunately, as a result of what we've seen today?
Yes, and I think, Rajiv, I'm a little mindful of the fact that the viewers will get a little bamboozled because it's a technical subject. It's not an easy subject for an ordinary viewer to understand, and I think it's important to leave the technicalities to the expert, and I'll stick to the other points. I think the problem is this battle is not just constitutional and procedural, it's also perceptional, and that's where the big problem is. The irony is that we have a system of double standards across the board. Not in the exact same vein, but the medical fraternity believes that they can only be judged by doctors themselves. So the MCI pretty much works on that formula. They don't like somebody else telling them whether something went wrong or not. Forget the medicine. Even media believe that they can be self-regulated. Do you think we would want the INB minister to interfere in the appointment of editors or in the appointment of a press council? So even the journalists believe that we are the only best judge of deciding what good content or bad content can be. In the very same vein, the judges are saying that we are the best judges to decide who should be heading a particular court or who should be appointed as a judge. The trouble is, and I think the fallout is, we've had decades of systems where people with slightly less levels of integrity or even competence have occupied important posts, and that is across the board, including the political class. And that's why you have a complete lack of trust over who should decide what this is. In fact, one of the big arguments, and I think Arghya will bear me out on this, has been on the definition of who the eminent persons are going to be. Now, my eminent person could be your crook. And it's a solution which is just not exists. It doesn't exist. Because after what happened with the FTI, you might think that, Gajendra Chauhan is an eminent person. Who is to know? And that is where the mistrust comes. The political class has allowed the judiciary. We could argue that there has been judicial overreach, there has been judicial activism, but that's because the political class has ceded space. And the public out there is also saying, good that the Supreme Court is taking on the political class. So, it's a complex issue. It's not a black and white issue. And the worry is that with a judgment like this, unless there is genuine reform of the Collegium system, you're back to the, you're going back to the past. You need reform. The parliament is right. You need reform in the present system. Would you concede that as a senior lawyer, that there are these allegations that judges who are appointed for reasons other than competence or merit?
No, there cannot be any doubt that a person sitting in Delhi, a CJI, how would he know about anything about a lawyer practicing at Chennai or Bombay? The question remains that there is no interview process, there is no testing process, there is no objectivity, there are no criteria laid.
Can I just for a moment tell you what the Union Law Minister said? He has reacted. Sadanand Gowda, who himself is a lawyer, has responded to the Supreme Court judgment regarding the National Judicial Appointments Commission. Gowda said, and I quote, that the will of the people is represented by the government. We will consult with the Prime Minister and the legal experts regarding the verdict before firming up the next move. Just a word from you, Arghya. Is there a possibility to challenge this judgment? It's a 5-judge bench. Can you go to a full constitutional bench?
No, that seems quite unlikely actually, because the 5-judge constitution bench is as authoritative as it gets. So unless there is any egregious error in the order, which I doubt very much, I think the judicial doors currently are closed. It's over to Parliament and the government. They are absolutely within their competence to reenact a legislation of some kind, but that depends on how much of a...
And what's the law there? If Parliament in the winter session, this was the argument we were making before you joined us, if Parliament in the winter session says, no, we are going ahead with the National Judicial Accountability Commission, 20 state assemblies have passed it, it's been ratified, the President has signed it, we want to still go ahead with it, they can.
Well, the Parliament has to go through that entire process again.
Sure, but they can.
Well, of course they can, because it's established law that the Parliament can take away the basis of a judicial opinion. It's established law. It's open to Parliament to do that. But the fact is, it's, as Vinay rightly pointed out, it's also a perceptional issue. It's not just a legal issue. And given the fact that it's a perceptional issue, that will signal an all-out war between government and the judiciary. Now, that's a difficult call for anybody to take.
But could the two sides sit across and try and find out if November 3rd is the date where you're being suggested, the court is saying we are open to reform, whether the definition of eminent citizens, for example, is laid down more clearly, whether maybe some kind of...
Let's get something clear. The eminent person is part of the constitutional amendment which has gone. So there is no question of an eminent person coming into the appointments process in any way, because currently it is the Judicial Collegium which is going to appoint. Now the Judicial Collegium is the Chief Justice and the 4 senior most judges of the Supreme Court. They will appoint, and the government will certainly have a say in that appointment process. So certainly we can make out a case for improvement of procedure. How will this consultation between the Chief Justice, his brother judges, as well as the government happen? So there is a possibility.
But it's all left to the judges themselves. Effectively, they themselves will decide how to improve their own system. They are not going to take instructions, it appears, from Narendra Modi ji or from the Parliament or from the previous government. Well, they've drawn that line today. They are not going to go. It appears they've drawn that line clearly with the executive of the country. Yeah, so that you will not tell us how to appoint our own.
Well, that's not entirely fair, because as I was in court today and they said that they want both sides, that's the petitioner and the government, to come and give them suggestions. But you are right in saying that ultimately the ball is in their court. They
that's it. Do you really believe that the judges are in the mood to accept suggestions from the executive?
The question is that even if they improve, whether they will radically improve. That would be the question.
You know, the question that I will ask, and he raised the issue of a Justice Dinakaran, for example, a judge with a spotty record.
There are many such cases. There are many such cases.
Is pushed out and is sent then to the Supreme Court the High Court in Sikkim. Impeachment has clearly failed in our system. It's not worked if a judge is accused of corruption. Vinay, do you believe that therefore we have now reached the tipping point where the executive and the legislature are being told that this is as far as you can go and no further by the judiciary today? That in a sense that reveals the limitations of what Orgio believes was not what our original constitutional framers wanted. They wanted this process to be one of consultation, not one of concurrence.
Yes, and I think, Rajdeep, the concept of institutional probity is overrated. I think you really only have individual probity. There is nothing called institutional probity anywhere across the world. You can't say this institution is entirely full of people who got a very high moral standard. That doesn't exist. You really have individuals who will have high standards of probity.
I'm just going to stop you for a moment because we've got a first reaction from a former Supreme Court judge. Justice Ganguly is joining me at the moment. Justice Ganguly, your reactions as a former Supreme Court judge to what has happened. Have the judges protected their own turf and as a result decided that we will be unaccountable?
No, what I think the judges have protected is judicial independence. In our country, the experience of power being given to the executive in the matters of appointment of judges is very, very unfortunate. Now, I am asking you one question.
Sir.
Not an asking, I am suggesting my solution. Can the executive give me one reason why a judge, where a person like Justice Khanna could not be made Chief Justice of India?
No. Sir, 1 minute. I could turn around Justice Ganguly with due respect and say, could you give me an explanation for why is it that judges whose record is considered spotty, and I think that's a good word to use because the last thing I want to do at the moment is get caught in contempt of court. If there is a judge whose record is considered as spotty, what action will the judiciary take against its own? How many such instances have taken? Along with independence, is there not the question, sir, of accountability of the judiciary?
I agree with you that in recent times, the appointment made by the Collegium system, the recent appointments are not satisfactory. Some of them are very, very questionable. I agree with you. I agree with you that in recent times, the functioning of the Collegium system has not been up to the mark. But that is no doubt to scrap the system. You can improve the system.
So how do you improve it? So that's precisely, I think the argument, Justice Ganguly, if you could tell us briefly, how do you believe it should be improved?
Please listen. That is the reason why I think the judges have invited some suggestions.
So you give me one suggestion.
The judges have invited on 3rd of November suggestion from the learned lawyers, from the civil society.
So give me one suggestion that you feel...
The system is not working well. Okay.
So give me a suggestion that you think will make the Collegium system a little more transparent, will reduce the level of public mistrust.
I'll give you immediately a suggestion.
Yes.
Immediately.
Yes.
When you bring a judge to the Supreme Court, or when you make a judge a Chief Justice, his track record is there. I mean, how he has functioned as a judge, what is his integrity, these things are all there. So on that, there should be a proper assessment, an objective assessment. And that objective assessment must be, in making that assessment, there must be some disclosure.
Would you, when you say some disclosure, sir, would you, for example, put all the reasoning on a website? Would
no,
I
I don't know. I can tell you offhand.
No, I'm asking you. Do you believe the public has the right to know why a particular individual has been made a judge?
That has to be properly structured. Can you understand this?
Yes.
This has to be properly structured. But there cannot be a total blackout on the question of transparency and accountability.
I think that
the Collegium system, I must say, must be accountable and transparent.
Right.
I'll give you some examples. Recently, the way some judges have been overlooked and some judges have been appointed calls for serious criticism because an appointment of a judge is an exercise in constitutional power.
So I take your point, sir. Sir, I take your point. I want to go to Soli. I just want to go to Soli Sorabji, sir, former Attorney General, who's also. I appreciate Justice Ganguly, you coming and candidly saying there cannot be a blackout of how judges are appointed in this country and there needs to be greater transparency. Soli Sorabji, former Attorney General, joining me. Soli Sorabji, what is your first reaction to this judgment?
I'm surprised. But let me make it clear. I have not read the judgment. I don't know if there's one judgment, other judges have given separate concurring judgments. But I'm surprised because it was well accepted that the collegium system had failed. And the basic thing was, nowhere in the world do we have a system whereby judges appoint themselves. And the executive has no say except when there's reference made about the integrity of a judge. Then the executive will agree or not agree, but if they don't agree with the Supreme Court, then the judges have the last word. But as I told you, I want to see the reasoning.
Well,
it was clear that the collegium system had not worked.
Yes.
One minute, had not worked.
Yes, sir.
The question is, what was in the Act which was very destructive of judicial independence? If there were any provisions which were rather tending the other way, the judges could have read them down. The judges could have read into it some provisions, but to strike it down completely, I find it surprising. But as I told you, I have not read the judgment, so my comments will be really tentative at this stage.
Mr. Sorabji, I'm going to take a break. I want to come to that point because I want to explore what you've said. You made a very interesting argument, and this is fascinating because I think the stage is set for two concepts. Judicial accountability on one side, judicial independence on the other. And how do you strike that critical balance? I think that is the question. And has the Supreme Court been able to do that today, or has it failed in doing that? That's the question.